Right friends, welcome back to second capsule. This is India and justice delayed. In fact, some of the slides I have covered during editorial discussion, and here basic emphasis is on what is the present reality in the Indian judiciary and what needs to be done by executive as well as judiciary. Here look at the following news report. Recently Supreme Court directed the high courts to install CCTV cameras inside the courtroom in 2 districts of every state and union territory to be ensured within 3 months. Here, what is the objective of this decision? Basically, to improve transparency, for better case management and improving the public behavior. So, overall, the objective is to ensure mindset change in the Indian judicial system, and in tune with this decision, many reforms are needed in judiciary. Basically, by using this information and communication technology, wonders can be done in judicial system. And let us go ahead. India has got maximum strength of 31 judges in Supreme Court. I am talking about Indian judicial system. It has got maximum strength of 31 judges in Supreme Court, and 1079 judges are there in 24 high courts of the country, and Allahabad High Court is the largest with around 160 judges, and at present more than 40% of the judges vacancies are vacant, and this is because of the reason after the striking of this NJAC memorandum of procedure between Supreme Court and the executive could not be settled for a long time, and there are news reports now that this issue of memorandum of procedure was solved. And if you look further about pending cases, in lower subordinate courts, there are 2.85 crore cases are pending. In lower subordinate courts, 2.85 crore cases are pending, and in 24 high courts, 40 lakh cases are pending, and in Supreme Court, 61,000 cases are pending. So, right from Supreme Court, right up to the lower subordinate court, it is the same story. And if you look at the judgments in high courts, 94% of the cases in high courts, 94% of the cases are pending for 5 to 15 years. Then Allahabad, the country's largest high court, has got 9 lakh cases pending. I have already told you there are 40 lakh cases pending in high courts. In Allahabad High Court alone, 9 lakh cases are pending, and on an average, cases take 3 years and 9 months to get disposed of, and I am doubtful about this figure, though I have taken it from the news report, but 3 years and 9 months may be less, it must be taking more time. In Delhi High Court, considered to be one of the efficient in the country, takes 2 years 8 months to dispose of on an average. Right. Next, facts and figures. If you see, in our country, overall judges strength is 18,000. Law Commission recommends a total of 40,000 judges. And if you look at it from some other benchmark, modern society needs 50 judges per million population, whereas in our country, the strength is about 1/3. And at the same time, because of delay, who is worst sufferers? Worst sufferers are under trial prisoners. They are languishing in the jails for years, and no benchmark or time limit for disposal of cases situated in our country. Unfortunate part in our country is no benchmark or time limit stipulated, and number of adjournments are being given by the judges. Without looking into whether reason is there or not, they are giving adjournments left and right. That is another point to note. And now, proposed action plan. What is to be done by both executive as well as by the judiciary, basically to come out of this problem? Basically, executive part, in fact, center and state governments That is their job to infuse required manpower and financial resources. But the important point to note is, with the advent of information and communication technology, manpower may not be required, and Supreme Court must be in a position, or you can say judiciary must be in a position to embrace information and communication technology so as to fast deliver justice. Then another important aspect is, government is the biggest litigant in the courts. The basic problem is, the laws framed by the center and the states, some of the laws framed by the center and the states are ambiguous, and interpretation is difficult sometimes, and some of the persons may misinterpret them. So, the point here is, laws must be framed in such a way, they should be framed in unambiguous way. If the present government employees are not able to frame in unambiguous way, support must be taken, or you can say efficient manpower can be recruited through lateral entry at senior management levels. And whenever any loophole is there are several people to exploit the loopholes in the system. So, the most important aspect is, center and the state governments must frame the laws in such a way that they are unambiguous. Then third point is, the spirit of the constitution before inferring various provisions of the constitution. Whenever government is resorting to certain action, what must be in their mind is the spirit of the constitution. The constitution spirit is known to each and every one of us, and government's actions must be with a view to look at the spirit of the constitution. Then next point is, 2/3 of the civil cases in district courts are directly related to land or property cases. Here important aspect is, reforms are required in Indian land laws, and property details must also be mapped. It is a one-time exercise. All the state governments must take lead in this. Entire property, or you can say all the properties, must be mapped, and if possible must be tagged to the Aadhaar number of the persons, and land laws must be unambiguous, and in some of the states land records are not properly available, right? In the states which falls into the British presidency, somewhat the land laws are perfect up to some extent, and in some of the states the land laws are totally not up to the mark, or you can say land records are not properly up to the mark. Then standoff between executive and judiciary must be avoided, and inaction by center or states. Sometimes when center or states are not acting, Supreme Court is coming into picture. Sometimes it is leading to judicial overreach, and sometimes Supreme Court is inferring Article 142 so as to ensure complete justice. Sometimes Supreme Court is breaching its line, and experts feel that it is judicial overreach. So, these type of situations must be avoided, and coordinated action by both the organs is essential for well-being of the democracy. Next one is, in addition to reducing the government litigation, then dispute resolution mechanisms must be enforced. There must be a system before going to the court. There must be compulsory dispute resolution mechanism with a specific time frame. Then these cases will automatically reduce. So, this is the contemplated action to reduce the pendency of cases by the executive. And if you look at the judiciary, a lot more needs to be done by the judiciary. There is no benchmark for adjournments. There is no benchmark for disposal of cases by each and every judge. And there are summer vacation and other vacations. and these are the things which need to be changed immediately. Here, Law Commission in its 245th report suggested rate of disposal method. The rate of disposal method must be enforced. Here, number of judges required at each level to dispose of a particular number of cases, they can be calculated on scientific basis. And second important aspect is judiciary must introspect when 2.85 crore cases are pending in lower courts and when lakhs of cases are pending in high courts. Judiciary must introspect about the colonial practice of long court vacations. What is the need for court vacations? This is not understandable when 40 lakh cases are pending in high courts, 2.85 crores of cases are pending in lower courts. Then judiciary must establish benchmark for clearing of cases as in the United States of America, where it is 3 years. Some benchmark must be there. Without benchmark, what happens is the cases are getting pending for 10 years, 15 years, 20 years. This assumed significance as 11% of the cases. Please look into this figure. 11% of the cases pending in lower courts are more than 10-year-old. This is important aspect. Most of the times, lawyers charge on per hearing basis. Lawyers who are representing the clients are charging on per hearing basis. Hence, more benefits are accruing to the lawyers. Hence, adjournments must be minimized. Then, judges must also refrain from accepting frivolous public interest litigations on minor aspects. If some public interest litigation petition is coming to the court, they should outright reject that. Transparency and accountability must be increased in judiciary. This is the need of the hour. Another important, the last point and the most important point is information technology is to be utilized by which it is possible not only to clear the cases, but transparency will also increase. So, in a nutshell, not only executive, a lot more needs to be done by the judiciary so as to put the judiciary on track, basically to reduce the pendency of cases and for faster delivery of the system. If you look at Singapore experience, reforms were undertaken in judiciary in 1990s. It gave excellent results. 96% of civil cases and 99% of criminal cases were disposed of in 1999, and now the average length of commercial cases fell from 6 years to just 1 year 3 months. So, when substantial changes could be made in Singapore judicial system, why can't they be done in India? Only willpower is required. Right, friends? Let us hope that all these things will be sorted out, and at the same time, judiciary will be on the fast track to ensure speedy delivery to the citizens of the country. Let us hope, and with that hope, we are concluding this second capsule. Have a nice day. Thank you.